The grounds for divorce in Texas are pretty simple. Texas is a no-fault state, so that means anyone who wants to file a divorce can file a divorce because it's Tuesday and you want one. Technically, what the code says is that the marriage has become insupportable due to a conflict of personalities that destroy the legitimate ends of the marriage relationship. So that's a big, long way of saying that people don't get along anymore and the marriage ain't working. So that's all it really takes. If you feel like the marriage is no longer functional, it's not serving its purpose anymore, then that's how you know it's time to file for a divorce. So let's talk about what that looks like. If you're in a spot where, you don't feel like you and your partner are on the same page, you and your spouse, you don't have each other's back. Some folks have separated their accounts because they don't trust each other with the money. We have to set up rules about who deals with the kids and who doesn't deal with the kids because we don't deal with the kids well together. We undermine each other with the kids sometimes. There's lots of different ways to get off of the same page when you're in a marriage that is old and tired and is no longer functional. Where you really run into problems is where resentment starts to build. So obviously, if people get off the same page, they get out of alignment, you've got options like marriage counseling and things like that, where you can get in and talk to people and kind of air out your differences and see if you can mend the relationship. But when resentment has built and it starts getting stressful just to be around your spouse, that's how you know that your marriage has probably run its course. Now, I'm not saying that you have to file divorce right away, of course, but at a certain point, you'll realize that you'd be happier without your spouse than you are with your spouse. And certainly, if your spouse isn't engaged in trying to rehabilitate the relationship, trying to restore the happiness, if your spouse won't come to counseling with you, that's probably a sign. That probably tells you all you need to know. So when it comes to insupportability, that's a fancy word for saying it doesn't make sense anymore. Now, obviously in Texas, you also can claim fault in the marriage. So if the other side has committed adultery, if the other side has been cruel to you, there's family violence, there's some kind of fraud or something like that, of course, you can claim those as a reason for the breakup of the marriage. You just don't have to. And there are numerous reasons why, even if those things are true, you may decide not to claim those. For one thing, marriage documents or divorce documents are public record. So imagine, your kids grow up someday and they want to find out what happened between mom and dad. And here's your divorce petition that says dad committed adultery or mom committed adultery. Your kids are going to see that someday. Right? So maybe we decide not to put that into your pleadings because ultimately it may not have much effect on your divorce. And why would you want to put your dirty laundry out into the public domain? Okay. So just because there is fault in a marriage doesn't mean we have to claim it. And there's certainly no requirement that you claim it because Texas is a no-fault state. So really the question is when you want to file, not necessarily how you file. Dividing the assets in Texas is often really pretty simple. It can be complex, of course, and this is another reason why you need a lawyer. But Texas presumes that everything that was accumulated by the spouses during the marriage is community property. So you get married, you buy a house, you buy cars, you buy a toaster, you buy, stuff for the kids. Texas presumes all that stuff is community property. Now, obviously, things for the children, the court believes belongs to the children, and we don't ever fight about kids stuff, right? But what about the income from the various jobs? Husband works, wife works, and that money is coming in. That money is community property. Wife's got a retirement plan, husband's got a retirement plan. Those retirement plans are community property if they started during the marriage. Okay, so a lot of folks get married in Texas, fairly young. And then as the marriage goes, they move up and they improve their careers and they're able to accumulate more things. Sometimes you have rent properties. Sometimes you have timeshares, right? Timeshares are real estate, right? When we start talking about, dividing the property, timeshares count too. So things can be relatively simple in a divorce because all those things are community property, presumably. We don't have to divide every single asset. We just divide the estate. And so a lot of times, if you think about dividing marital property as a ledger, where you have a whole list of the property, and then you're going to put certain property in the husband's column, certain property in the wife's column, or we'll say the retirement account goes in the husband's column and the house goes in the wife's column. So it's sometimes possible to put whole assets into one column or the other so that they can kind of equal themselves out when we get to the bottom of the ledger. So I don't want to get all overcomplicated about, start thinking about spreadsheets, but we do it in spreadsheets, right? So we can start accounting for the value of different property. If a house has $100,000 of equity, but there's a $300,000 retirement plan, obviously those don't offset each other. So if we put the house in one party's column, then we're going to need some other assets to offset that retirement, or we're going to end up splitting part of the retirement off to the other spouse so that we can equalize the assets. Now, here's something really important to understand. There is not one single thing in a Texas Family Code that says a party is entitled to 50% of anything. In Texas, what the court is looking for is a just and right division. So for us as lawyers, we start dividing things and we start looking at it in terms of this side of the ledger or that side of the ledger. But for the court, what the court is looking for is what is fair under the circumstances. What is a just outcome? And so the court will start looking at, spouse 2 has been a stay-at-home spouse for a decade, and they're going to need some assets so that they can start their new life after the divorce. Or we might look at, spouse 1 has a lot of retirement, and they want to keep the retirement. The other spouse needs some liquid cash to get their life going. And so the court looks at how can we do this in a way that sets these people up for success. So if we presume everything is community property and we want to do a just and right division, that is the analysis that the court is going to do. On the more complicated side, sometimes you have separate property. Sometimes you have a house, the parties buy a house and then they get married. Well, now the house is not community property, it's separate property of one or both parties. And so that can get complicated. Sometimes a retirement was started before the marriage and then the parties get married. So there's some separate property retirement and then there's community property retirement. And then after the divorce, separate property retirement will continue to accrue. So there's a lot of different things that we look at. And this is another reason why if you're looking at a divorce, you probably need lawyers. Certainly if you've got a house, if you've got kids, if you've got retirement assets, if you've got numerous bank accounts, you've got savings accounts, you've got brokerage accounts, you've got investment properties. If you own a business, if you have a little LLC that you and your spouse run, or you run, or your spouse runs, all of those things have value, and we got to calculate how we divide this estate in a way that sets the parties up for success. Now, keep in mind that me as a lawyer, my job is to make sure my client is set up for success. I've got no duty to the other party. So if you get served with divorce papers, your spouse is represented by counsel, that lawyer's job is to be setting their client up for success, to get them the best split of the assets that they can get. You need that on your side as well, right? You cannot listen to the other lawyer. You can't listen to your spouse about what they think is fair, right? So if the other side has a lawyer, you for sure need a lawyer. And if you've got pretty much any asset, you're probably going to want a lawyer to get a divorce decree that at least explains exactly how that asset is dealt with, so that you don't have those complicating factors after the divorce is over and you've got assets that weren't divided. So there's a lot of analysis that goes into dividing an estate before, during, and after a divorce. So this is what we do for a living. And, people who aren't lawyers, you don't do this for a living, so you don't even know what you don't know. And this is why lawyers, this is how we make a living, is figuring these things out and trying to get you set up for success. Alimony isn't a real thing in Texas. Texas is not an alimony state. We don't do that here. There is a thing in Texas called post-divorce spousal maintenance. The family code defines how you qualify for post-divorce spousal maintenance, and the standard is high. I want to contrast this with child support. The code presumes that child support should be happening. Okay, so under most circumstances, when parties get divorced, there's going to have some child support. The code presumes that spousal maintenance should not happen. All right, so that's a difference in the way the code is written when it comes to child support versus spousal support. Essentially, as a policy, Texas doesn't want me to file for divorce, but then have my hand out to my spouse to help pay for my living moving forward after the divorce. What the code wants to do is sever those ties so you can live your life and I'll live my life. Now, obviously, we still have kids. We'll talk more about child support in another video, but I want to make sure that I want to contrast the theory behind spousal maintenance in Texas. So when it comes to qualifying for spousal maintenance, you have to be married 10 years to even qualify. So that's part of the analysis. Have you been married 10 years? If you haven't been married 10 years, the analysis stops. You're done. You're not going to get it. Okay. Now, obviously, if one of the spouses is disabled, or if there's, family violence that has occurred and is preventing that spouse from being able to function like a normal person moving forward, they can maybe be able to qualify for some spousal maintenance then. But generally speaking, if you've been married 4 or 5 years, you want a divorce, spousal maintenance is off the table, right? But let's say you have been married 10 years or more. Then the analysis starts. Does the spouse have the ability to meet their minimum reasonable needs, right? That does not mean to continue your standard of living. It does not mean that you want to keep living the good life. It means, can you meet your minimum reasonable needs? Can you afford an apartment? Can you afford your food, your gas? Can you pay your utilities? If you can do those things, then the analysis stops. What do we calculate when we're trying to figure out that math? So we look at your expenses, and then we also look at how much child support are you getting, because that's money coming in your household. What property did you get in the divorce? If you got $200,000 of retirement split in the divorce, well, you've got money you can live on. So the analysis is going to stop right there. The court's not going to give you spousal if you just got a big piece of retirement income. Okay. So the assets that you have at the time of the divorce calculate into whether you qualify or not. Now, let's say you do qualify. So you've been married at least 10 years. You can't meet your minimum reasonable needs. Then the second part of the analysis is, can the other spouse afford to pay you? If the other spouse is making $40,000 a year, can barely pay their own bills, even if you need the money, there's no money for the other spouse to pay you, you're done. It looks like a complex analysis in the code. It takes several pages in the code to talk about all the factors that the court looks at, but ultimately you have to be married long enough to even qualify. And then, do you need the money, and can the other spouse pay it? And if the answer to all that equals there's no money for you, then there's no money for you. And so you cannot count on alimony in Texas. You can't count on spousal maintenance because the court is disinclined to give it to you. What does that mean for you? That means, especially if you're a stay-at-home spouse, there is no substitute for being self-sufficient. If you are a stay-at-home spouse and you haven't worked in a number of years and you know a divorce is on the horizon, you need to get a job. I can't sugarcoat it. you've got to get to work and start becoming self-sufficient, because spousal maintenance is very likely not in the cards for you. And even if it is, it's only going to be for a year, maybe two. The courts don't like to give it. You cannot rely on it. So my strong advice is don't count on spousal maintenance. If you're looking at a divorce, let's do the analysis. Let's see if we think you have a good shot at it. But I'm just telling you right now, the courts are not inclined to give it. It's not easy to qualify for. And ultimately, the best situation would be for you to be up and to the right on your own without requiring your ex-spouse, to continue to fund your life. In a typical Texas divorce where there are no kids, a whole divorce decree could be 6 or 8 pages long. If there are kids, a divorce decree these days is like 60 plus pages, right? When we say a standard possession schedule, that turns into like 12 pages of text in a divorce decree. It's very complicated, it's very specific, and it's all outlined in the family code. So when we talk about divorce with kids, you just got to know it adds a lot of complication to the divorce process. The code presumes, Texas presumes, that both parents love the kids, both parents have, and they're invested in the kids, they have a duty to support the kids. Texas presumes that one parent should be the primary parent. And that parent is going to establish the primary residence of the children and is going to have certain rights and duties to the children that account for that parent having the majority of the time. In Texas, there is also the presumption that the other parent should have regular and frequent access and possession to the kids. So the standard possession order in Texas these days is roughly a 47 to 53% split. We're only talking about 15 or 16 days of difference, but that's not 50-50, okay? Lots of people these days come into our office and they have an agreement or they want a 50-50 type schedule. We're happy to do that, but understand that if we go to court, if the judge follows the black letter law straight out of the code, you're not getting a 50-50 possession schedule. Okay, because the code doesn't even address a 50-50 schedule. So I know some other states, notably another conservative state like Florida has recently moved to a 50-50 presumption. Texas still doesn't. Texas presumes one parent should be slightly more equal than the other. So that is what it is, right? So that really sets up a lot of conflict in a lot of cases. First things first, we go to our first hearing and we're having to argue about who's going to be the primary parent, because if you lose that battle, you're paying child support, because that's the other side of that coin. Texas presumes that one parent should be paying child support. And so if you are the primary parent, the other parent is presumed to be paying you child support. That's what the court presumes, okay? So so there's a lot of battles right at the very beginning of a case fighting over who's going to be the primary parent, because the child support is a necessary consequence of losing that battle. And so that's an unfortunate situation in Texas. I'm not a proponent of how Texas does that. I think Texas needs to get up with the times. But that's not up to me. I don't make the law. I just fight for my client in court. I've represented lots and lots of folks who lose that battle. I've represented lots and lots of folks who win that battle. But fighting over, primary custody of the kids is one of the most intense parts of a divorce. And so if you've got kids, it definitely complicates it. And one of the hardest parts, I want to put this in this video because I think it's so important. One of the hardest parts about finding out a divorce process with kids involved is it's easy to build so much anger and resentment toward the other parent during that fight. During that legal proceeding, we're over here arguing about who's going to be the primary parent and who's got to pay child support and who owes me money and who makes this decision and that decision. And we forget the fact that these kids are young kids and you're going to have to co-parent with this other person for the next decade. The kids until the kids age out, until they're 18 or graduate high school, whichever happens last, y'all have still got a co-parent. My personal preference would be for parents to model good behavior, model grown-up behavior, and to be able to sit side by side in the stands when those kids are graduating years from now. I would love a spot where my clients have a co-parenting relationship that doesn't require them to go back to court every 2 or 3 years fighting about something else until these kids graduate. That's my personal dream. I can't change how people are. I hope that my client will follow my guidance. That doesn't mean the other parent will. So we're happy to help you in your divorce. If the other parent drags you back to court in a couple of years, we can be here for you for that too. But our personal philosophy around here is the divorce is temporary. The co-parenting is much, much longer. And so it has to take some priority. That's our belief, and that's what we try to help our clients achieve.